Hi, I'm Fred Satilli, and here's a chapter of HTFN FemiNazi that I've been eager to get to. This is chapter 20, Civil Rights. Subtitle, Removal of Rights and Responsibility by the Court. Why did I go to California? I was threatened with jail by both the court and in no uncertain terms by Stacy for no productive or even legitimate reason. Two excerpts from legal documents that follow show court actions so egregious as to be almost unbelievable. On September 28, 1998, item E on the first excerpt prohibits me from standing up for myself in court from that time on. This actually happened in America. Below that excerpt is my response. Because I was disenfranchised from the American legal system by the court, I cannot be charged with any responsibility for my actions after that date, since I was stripped of any ability to defend myself legally. I was forced by the court to take desperate action. Do not take the term desperate action lightly. The use of the term is not frivolous drama. Think and consider what desperate action is. Ask yourself if you have ever been truly desperate, not a little desperate, truly life and death desperate. Have you ever fled anything and everything and everybody you know? I was forced to make a desperate decision. I had no power to speak. Can you imagine? My First Amendment right, America's most precious right, was capriciously stripped away from me. Not even a lawyer was allowed to plead on my behalf. The civil rights of my case cannot be denied. Once power is stripped away, responsibility is also stripped away. I had no power in court to shape my destiny, so I had to leave the jurisdiction of the court. It was my only option. Someone, however, did have power over me, and thereby responsibility for any following events. It was the lawyer, Lori Bernstein, the judge, James Convery, and ultimately Stacey Gray, who still does. Look what they did with their power and responsibility. They banished me, forced me into poverty with no avenue for remedy, stripped the entire parental side of their family from our children, further alienated them from normalcy by immediately changing their names, forced our children to live out their lives protecting a lie. I recently obtained a copy of the complete court file in case number FM0724 blah blah blah. That file contained only the following documents. A complaint for divorce by John Fred Satilli filed May 2nd, 1998. Case management order dated September 25th, 1998. Order, custody and pendant late relief filed September 29th, 1998. And D, civil action order, direct payment credit, dated October 19th, 98. E, order adjudicating plaintiff in contempt for violation of litigant's rights for his willful noncompliance with the September 28th, 1998 court order, dismissing plaintiff's complaint, striking plaintiff's answer and affirmative defenses to defendant's counterclaim, entering plaintiff's default to defendant's counterclaim, and barring plaintiff from testifying at the trial in this matter, amongst other things. My response? January 12th, 1999. Contempt of court order against Fred was void because the court did not have jurisdiction to enter such, as no contempt occurred in the presence of the court as required by Rule 110-1. The court did not issue an order for arrest or even to show cause, specifying the acts or omissions alleged to have been contemptuous as required by Court Rule 110-2. A notice for enforcement of litigants' rights, which was the basis of the December 17, 1998 hearing, is not a contempt hearing if all parties agree under Rule 110-3 and the remedies under Rules 423-2, failure to be sworn or answer a question or permit discovery after ordered to do so, and 423-4, failure of a party to attend his own deposition after proper notice, do not apply in this case, as there was not an issue of Fred not attending a deposition, failing to be sworn, answering a question, or providing discovery after being ordered to do so. In other words, they found me guilty of not doing something they didn't ask me to do. That wasn't in the book. I just thought a moment of clarity was in order. There is not any record of Fred violating any discovery order, including attendance at depositions or answering questions. The dismissing of Fred's complaint and the striking of his answer and affirmative defenses to the counterclaim under Rule 423-2, and entering a default and ordering attorney's fees under Rule 423-4 in the January 12, 1999 order was void. This is a key now. Lori A. Bernstein knew or should have known that the January 12, 1999 contempt order was void when she drafted it and presented it to the court. Aside out of the book a moment. This is all from the contents of the court file. In other words, all these things about the contempt and everything, there's no record of it in the court file. It didn't happen. Please be abundantly aware that my rights were stripped away because of a concocted charge of default. Nothing in the court file shows that a condition of contempt ever occurred. One would have to assume that default was egregious enough to merit disenfranchisement from my constitutional rights. During my litigation regarding the fraud upon the court that was pursued through 2010 and 2011, Stacy defaulted 8 times. Well, for her, there were no consequences. Her defaults were from actual legal litigation that is on record, not from litigation of which there is no record in the court file. Do you get it? They said I defaulted somewhere, and they threw the book at me, despite the fact that Stacy defaulted many, many, many times. No consequences. Why? Whose master is being served here? Is a balance of equal law? I'm speaking now out of the book, but man, oh man, let's be fair. Back to the book. My simple question is, why are there no civil rights attorneys for family law cases? The answer is simple. The FemiNazi lobby. All I can say is, Hotsy-totsy, FemiNazi, you certainly have developed a splendid suit of armor. Thanks again. I'll be back soon with Chapter 21, which is mental illness. And that chapter is the final one into getting to know the author. After that chapter, we shift gears a little bit and move from the past into the present. Thank you.